Well, when a person has a looming lawsuit, there are kind of two approaches. First of all, you have to be very careful of what we call fraudulent conveyance. Fraudulent conveyance is a situation where you are seeing a pending financial crisis and you're trying to be able to take some backdoor sneaky ways of being able to protect your assets, such as bankruptcy. If you know you're going to be taking out bankruptcy and you got a whole bunch of money and you go out and you give it to all of your friends or your family members and tell everybody not to say anything about it, then you go take out bankruptcy, that's called fraudulent conveyance. And the judge can actually order those monies that you paid out to those other individuals back in and be used to help pay off your creditor. If you're in a lawsuit, therefore, you already know who the creditor is. And so in theory, going out and setting up these structures, knowing who your creditor already is, and knowing that you're trying to do this to defraud them, it could be construed by the courts as fraudulent conveyance. However, some attorneys say that because these structures do in fact have a great intimidating factor as well, they would say go ahead and set up these structures anyway, put your assets in it, and then if the creditor, the plaintiff complains and the judge rules that you are subject to fraudulent conveyance, then you'll just have to take the monies back out again. But I know that some attorneys would believe that what have you got to lose? You put your assets in there, and if they're protected, they're protected, and if they're not, they're not. The rule here is to try and do as much asset protection as you possibly can before you know what the lawsuit is and before you get into trouble. But if you're already in that situation, maybe you can still put these structures into place knowing that they may not work for you if it's considered as fraudulent conveyance.